Hello everyone, welcome to Legal Darshan. In the fifth lecture of Jurisprudence and Legal Theory series, we are going to talk about legal aid services in India. So far, we will be covering the case of Husainera Khatun versus State of Bihar, legal aid as a constitutional mandate, the articles empowering legal aid in Constitution of India, how did Legal Aid Authority Act came into existence, Committee for Implementation of Legal Aid Services in India, how it was formed under Justice P.N. Bhagwati, and the recommendations of C Rpc under Section 304 that supports legal aid in India. So, legal aid is an essential element for access to justice. Heavy cost of litigation and unawareness are two bigger obstacles in securing justice and validating the rights of poor in our country. So, to help the poor and illiterate citizens in prosecuting their claims and their rights and strengthening their rights, legal aid was required. Therefore, it is considered to be an instrument to achieve equality before law as provided by our Constitution. So the first legal aid committee was formed in 1972 under Justice Krishnan Iyer. He established a lot of principles, like the main task of the committee was to consider the question of making available to the weaker sections of community and persons of limited means in general and citizens belonging to the socially and educationally backward class in particular the facilities for legal services so as to bring among them an awareness of their legal and constitutional rights and their obligations and the avoidance of unnecessary litigations. Legal aid was provided in proceedings before civil, criminal and revenue matters so as to make justice more easily available to all the communities and sections of these communities. According to the report of Justice Krishnan Iyer, a properly organized and implemented scheme of legal aid would have many pros, like it will educate the general mass and make them legally aware, it will act as a shield against exploitation and a mean of spreading the justice within the framework of law. It would discourage the resort to extra legal methods of obtaining redressal, and it will strengthen the respect of law in the eye of poor and backward classes as well. Next, in 1976, Justice P.N. Bhagwati's committee was formed. It added to the recommendation of Justice Krishnan Iyer committees the following recommendations. The fund for legal aid must come from the state. There is need for conciliation in litigation, and there must be conciliation cells with every legal service committee. Access to justice must be easy. Voluntary wings of the bar must be mobilized for legal services and for free. Legal services clinics must be created in universities and law schools, and legal aid must be provided specially to working class, women, scheduled castes, and tribes and other weaker sections. So to administrate legal aid program, there was a committee which created the infrastructure for legal services organization consisting of a national legal service committee, block, taluka, tehsil legal services committee, high court and supreme court legal services committees, and special cell for different categories of weaker section. It was done to avoid the delay in implementation of the recommendation. Hence came the 42nd Amendment Act 1976, which inserted Article 39A as an instrument to access of justice through directive principle of state policy. The article stipulated equal justice and free legal aid for all those poor people, women, weaker section and scheduled caste and tribe, and also for the accused person who cannot afford the fees for legal practitioners to achieve justice in the court of law. So how Article 39A puts stress upon legal justice is the language of Article 39A is formed in such a mandatory way that it clearly uses the word shall twice therein. The state shall secure that the operation of the legal system promotes justice on the basis of equal opportunity, and shall, in particular, provide free legal aid by suitable legislation or schemes or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic and other disabilities. In our constitution, there are several articles that empowers justice for everyone equally. Article 39A, which we just talked about, free legal aid under DPSP. Article 22(1), which give convicts the rights to afford or to talk to legal practitioner. Article 226 and Article 32 give rights to file a writ petition if their fundamental rights are violated, and Article 14, 19, 21, the Golden Triangle, has its principle laid down in such a way that justice cannot be denied to any citizen of India. So justice and free legal services are essential element of fair procedure. Coming on to legal aid is implicit in Articles 14, 19, 21 and 39A. It was not possible to reach the benefit of the legal process to the poor, to protect them against injustice, and to secure to them their constitutional and statutory rights until there was a nationwide legal service program to provide free legal services to them. Therefore, in Husainera Khatun versus State of Bihar, a landmark judgment of 1979, it was observed that Supreme Court strongly recommended to the Government of India and state governments that it was the high time that a comprehensive legal service program should be introduced in the country, and the legal aid was made a constitutional mandate in the Supreme Court's observation. It also stated that the state cannot avoid its constitutional obligation to provide free legal aid to the accused by pleading financial or administrative inability. The state is not only a constitutional mandate of equal justice implicit in Article 14 and Article 21, but also therein compulsion of the directive embodied in Article 39A to ensure fair trial, and whatever is necessary for this purpose, that has to be done by the state. The right to free legal service is therefore clearly an essential ingredient of reasonable, fair, and just procedure for a person accused of an offense, and it must be held implicit in the guarantee of Article 21. After a lot of recommendations in 1987, the Parliament enacted Legal Services Authorities Act 1987 to provide statutory legal service authority at national, state and district level for effective monitoring of legal aid programs. Therefore, Center for Implementing Legal Aid Services, that was under Justice P.N. Bhagwati. The committee was known as the Committee for Implementing Legal Aid Schemes. The committee was required to formulate and implement comprehensive legal aid schemes on a uniform basis throughout India, monitor the scheme programs, and recommend such other steps as necessary steps to secure proper working of legal aid schemes. This SILAS was replaced by National Legal Service Authority by Honorable Justice R.N. Mishra, who then played a key role in enforcement of the Act and played as the Chief Justice of India at that time. Coming on to how Criminal Procedure Code supports legal aid scheme, it is given in section 304(1) of the old code of 1898 as well as section 303 of the new code of 1973 that any person accused of an offence before a criminal court or against whom proceedings are instituted under this code may of right be defended by a pleader of his choice. Section 304 C Rpc of the new code of the new code of 1973 codified the recommendation of the 48th Law Commission report for free legal aid assistance by the state for all the accused who were undefended by a lawyer for want of means. Section 304 reads, legal aid to accused at state expense in certain cases. Therefore, where in a trial before the Court of Session the accused is not represented by a pleader, and where it appears to the court that the accused has not sufficient means to engage a pleader, the court shall assign a pleader for his defense at the expense of the state. The second subsection states, the High Court may, with the previous approval of the state government, make rules providing for the mode of selecting pleader for defense under subsection 1, the facilities to be allowed to such pleaders by the court, the fee payable to such pleaders by the government, and generally for carrying out the purposes of subsection 1. The state government, in the third subsection of Section 304, it is stated that the state government may by notification direct that as from such state as may be specified in the notification, the provisions of subsection 1 and 2 shall apply in relation to any class of trials before other courts in the state as they apply in relation to trials before courts of session. Therefore, a bare reading of Section 304 makes it very clear that in a criminal trial, the magistrate or the session court before whom the accused appears must be held under an obligation to inform the accused about his legal rights, about he can afford a legal practitioner by the means of legal aid schemes, and if he is not represented by a private lawyer or on accounts of poverty, ignorance, or any disability, he is entitled to free legal services at the cost of the state. Legal aid is a constitutional mandate as held down in Husainera Khatun versus State of Bihar. So this was it for legal aid scheme in India today. I hope you liked the video. If you liked the video, please like, share and subscribe to Legal Darshana. Also, feel free to contact us, drop us any query, suggestions, information at legaldarshana@gmail.com. Thank you for watching this video.